Good evening and welcome to the PI Show. I'm Harry Nowicki and with me is Tony Carbone and our special guest Martin Smith, who has been a frequent flyer.
Yes.
Martin, tonight we're talking about legal cases involving the airlines, and there's criminals obviously who are flight risks, but tonight we're talking about injuries arising out of matters associated with airlines. So it's a complicated area of law, but there's some interesting cases. Before we get to that, Tony, there's a new segment called What's in the News.
Yes, Harry, we're on that topic, very topical subject of bullying. A 17-year-old schoolgirl received a $290,000 out-of-court settlement for bullying that went over on many, many years. This girl here had been spat at, gum had been put in her hair. She was just tormented by quite a few of her students.
I think the newspaper report says it's over a period of 2 years there was bullying, and then she eventually changed schools.
Yeah, well, what happened, as a final straw, one of them threatened to shoot her, so the family packed their bags and left Kerrang and went to another school.
And I think there was some emails and the social networking sites was also involved.
She had all sorts
I think
of
it's not
symptoms,
uncommon for bullying to take place. This seems at the extreme end.
Yeah, no, look, her symptoms were pretty severe, and in the end she had suicidal thoughts.
But who sued the school?
The school was sued by the parents on her behalf as her guardians, and the settlement was achieved out of court. She's 17 years of age, so it's a matter that has to be approved by a court, by a judge, because she's a minor at law. And the thing is, she would have to go through certain thresholds. She would have to get more than 10% whole body impairment when assessed using those AMA guides for psychiatric injuries.
And $290,000 seems a lot of money.
No, look, it would have covered general damages, which is pain and suffering, loss of enjoyment of life. She would have had some loss of income into the future, I would imagine, and also it would have covered her past and future medical treatment. So it sounds like a lot, but it's probably not a lot, Harry.
Okay. Well, again, that's a story that was in the press recently, and just shows you the trend in court cases, and it's a significant settlement that is ultimately approved by a judge in the Victorian Supreme Court.
Yeah, look, there was other matters that have been in the news this week, Tony. A girl down near Geelong, etc., was attacked by a knife in the schoolyard. All the knife threats, etc. It just does make you wonder how far the extensive bullying does go in the community. If people have got any questions, my advice to them will be go and seek some legal opinion from a lawyer.
Yeah, it's just to protect your child's interests. Absolutely. I mean, it's not a case, you don't have to sue in every case.
No.
I mean, bottom line, you might have to just speak to someone and you sort it out.
That's right.
But tonight we've got a program devoted to airline cases, and there's a very interesting history with airlines and how injuries which arise in the course of travel on an airline or embarking or getting off an airline are covered. There's what's called a Warsaw Convention. It was ratified by airlines in 1929. And there's been modifications and amendments ever since then. But the Warsaw Convention has been adopted by most countries around the world, including Australia, so it's part of Australian law. So the leading case in Australia was a case of Mr. Povey, who sued Qantas Airlines for a stroke that was suffered arising from deep vein thrombosis. When he travelled from, I think, Sydney to London and back again, and he sued in the state of Victoria. He lost in the first. Sorry, he won in the first instance. The airlines appealed. He lost in the Court of Appeal. Then it went to the High Court, and the High Court, I think 7 judges in the High Court, dismissed the appeal, and Mr. Povey had no right to claim damages arising from his stroke. He had serious injuries, but the wording of the Warsaw Convention and what your rights are was against him.
Harry, it's a very, very sophisticated area of the law that, as you said, it started in Warsaw. There's been cases all around the world. There's been cases in London. There's been cases in the Supreme Court of America. United States Supreme Court, obviously the High Court with 7 judges.
And the House of Lords as well.
Yeah. So
what's significant, Marty, is it turns on the definition of accident.
Yes.
You know, that's what the court have said. You know, you've got to look at the issue and look at the incident and is it an accident? If it's not an accident, you don't get covered. And they said that in Povey's case, the deep vein thrombosis wasn't as a result of an accident.
correct.
The accident's got to be what they call an external event. Something's got to happen externally to someone. That's got to be an unusual event. So in Povey's case, they said, in effect, Qantas may have failed to warn Mr. Povey about the dangers of airline travel and DVT, and they might not have told him to get up and exercise and walk around in the course of a long flight. So they didn't do certain things. However, there was no accident as such, which was external to Mr. Povey, which caused the damage. So
It's a bit more than it's due to the unexpected or unusual event that is external to the passenger. A similar case to that, Harry, was a woman that was rendered deaf because of the flight, the loss of air pressure, but in those circumstances she failed because she couldn't prove it was an accident.
So there was no external event which was unusual. It was simply the airline changing altitude.
Yes.
And
Well, there was a lot of debate about the issue of failing to warn, but the courts looked at that and they said that doesn't constitute an accident in itself.
But it's interesting, Tony, if you hop on an international flight now, they have the tape that comes on just after you've taken off, that you've got to move your legs, exercise, move your position, etc. That's all flowed from Povey.
A lot flowed from that case because,
absolutely.
I mean, there was a lot of plaintiffs waiting there to sue.
there's a class action in effect that Mr. Povey was the lead litigant, but there were in Victoria or around Australia, there were, I think, 300 people waiting on the outcome of that case.
And there was worldwide, Harry, there would have been.
And there was others outside
many.
Of Australia as well.
So it was a policy decision, wasn't it, gents?
No, well, it was the wording of the
Wording of that convention.
of the act. I think you've got to go back to French civil law, Tony, and French civil law. Monsieur Carbone, Monsieur Smith, is that it's not a fault-based system.
No.
We're familiar with fault-based systems, but we're having a short break now, and we'll come back after the break and discuss more injuries arising out of airline cases.